Why don't game wardens need a search warrant to search your hunting property or your coolers and trucks for illegally taken game? I've often wondered where game wardens get this authority. There's two different situations to consider when talking about a game warden's authority to conduct searches without a warrant or probable cause. The first is coming onto private property to conduct searches and stings for suspected game violations. Second is searching your cooler or your truck, as well as these stop and checks for suspected illegally taken game and fish. Let's address them in order. In the first instance, the U.S. Supreme Court has continually upheld their decision in Hester versus U.S. that an open field doctrine applies to large tracts of private land used for hunting and fishing. So what is the open fields doctrine? Well, it states that the special protection accorded by the Fourth Amendment to the people in their persons, houses, papers, and effects is not extended to the open fields. This decision gave way to the Katz versus United States decision, which established a two-part test for what constitutes a search within the meaning of the Fourth Amendment. The relevant criteria are, first, that a person have exhibited an actual expectation of privacy, and second, that the expectation be one that society is prepared to recognize as reasonable. Under this new analysis of the Fourth Amendment, a search of an object or area where a person has no reasonable expectation of privacy is, in a legal sense, not a search at all. This does exclude your home or dwelling and the surrounding property, basically your yard. The second involves a game warden sitting at a boat ramp and checking everyone's cooler that's coming out of the water, or sitting at the exit to your hunting lease to check hunting licenses and trucks for illegally taken game. This authority is based mostly on a California Supreme Court ruling. Shocking, I know. In the People versus Maceo case, California Supreme Court ruled that said the need to protect wildlife for future generations outweighs the minor intrusion of a vehicle stop on a participant in a regulated activity like hunting or fishing. California Supreme Court ruling stated that people who hunt and fish have fewer of the privacy rights guaranteed by the U.S. Constitution's Fourth Amendment. The court believed that game wardens have separate duties and authority based on whether they're acting as law enforcement officers or conservation officers, and that, as conservation officers, they have a duty that supersedes the Fourth Amendment to preserve the natural resources of the state. The state of Tennessee ruled in 2022 that the open fields doctrine does not apply to their state wildlife officers, and that people do have a reasonable expectation of privacy on their privately owned land. They used their own state constitution as a basis for this ruling, and 16 other states have similar language in their state constitutions. So this ruling could open the doors for other states to throw out the open fields doctrine. What are your thoughts on this expanded authority that game wardens have? Do they have the right to stop and search without a warrant or probable cause? What about coming onto your private property and hide and watch, sometimes even video your hunting activities to find violations? Share your thoughts in the comments below.